The terminology is slightly odd. We talk about BCR for controllers, we talk about BCR for processors, but actually it's not that you're focusing on whether you're a controller and a processor, because it's entirely possible that that entities may be doing processing activities in the context of a controller BCR. It's about the data. So where you're talking about a BCR for controllers, it's about the data you control. So it would tend to be your HR data, your customer data, supplier data. Where you're talking about BCR for processors, it's third-party data, so where you're acting as a processor on behalf of somebody else. This just sets out the timeline for the process we've gone through in the Article 29 to get to this point about BCR for processors, and highlights the main documents. So I referred previously to WP153. Well, the equivalent for BCR for processors is WP195. The application form is 195A. And then there's an explanatory document, 204, which is the equivalent of WP74 and the combined rest of the documents. Since January last year, we've been open to applications for approval for BCR for processors, and I think we have 4 completed, 3 completed? 3 completed. But we have a number of other applications in the process. Just quickly going to take you through the draft regulation. In effect, this provides the legislative recognition for BCR for the first time. The 8th principle, in effect, is still in place in the regulation, and so the restrictions on transfers still remain. So the fact that it appears for the first time in a legislative document may be of some comfort to some of the DPAs and the countries that have had some awkwardness over BCR in the first place, given the creation of the BCR as a concept came from the Article 29 rather than from the directive specifically. It includes a BCR checklist and criteria for BCR, which are very similar to the information that you'll find already in the Working Party papers. BCR is a clear demonstration of accountability. We've been hearing in our last session about the importance of accountability. Well, BCR is a way of allowing a company to demonstrate in its own way how it meets all of its data protection obligations through its internal corporate governance, its policies, its procedures. These are sort of what I was saying before about sort of preliminary steps for prospective applicants. I'm not saying that you need to do all of these things or even consider them, but it's the points that seem to come up time and time again when I discuss the approach to BCR with applicants. So the first point would be an assessment of whether BCR is appropriate. It has this mystique, it's been created in people's mind that BCR is some gold standard of data protection. You get the approval from the DPAs, therefore it must be the best thing ever. But it may not be suitable for you. There is a long application process, and it may just not be the best thing for your organisation. What I would ask a company to do is to consider the data flows it has. Look at its entities. How many of them are there overseas? What are their data flows? How much data are they actually transferring? I have one example where I had a company with lots of EU entities, but they were exporting data only to one country. They're only going to India. So there was a question as to whether BCR was the most suitable thing in that case. It may be that they wanted to apply for BCR and have it for a small amount of data flows and a small number of entities and then expand it. But if that's all they were wanting to do, that's all they were going to do for the foreseeable future, it may not be worth their while making the application at this stage.